Thank you for joining us this afternoon and welcome to the SIAC Philippines webinar, Strategies for an Efficient Virtual Hearing, Considerations for Counsel and Arbitrators. I am Thea Elisa Vega, Associate Counsel at SIAC, and I will be your moderator for this afternoon. So we will be discussing virtual hearings, and the topic is still timely as we still try to learn the best practices for dispute resolution done remotely. This afternoon, we will discuss tips for counsel and arbitrators, as well as understand the due process considerations in virtual hearings. So for housekeeping rules, if you have queries, please kindly type it on the chat box. We will try to discuss it at the end, but we have also considered the questions that you have emailed to us earlier this week. So for this afternoon, without further ado, please let me introduce our stellar lineup of panelists. And I'm very privileged and honored to be moderating this session, and I'm also excited to hear the thoughts of our speakers for this topic. First, we have Mr. Andre Yap, SC. Andre was appointed by the Singapore Supreme Court to the rank of Senior Counsel in January 2003. Apart from being Senior Partner of Raja & Tan, Singapore, he also heads the international arbitration and construction practice of the firm. He has been recognized as a leading lawyer in the areas of international arbitration and dispute resolution by several publications. Apart from international arbitration, he remains active in commercial dispute work in court, and many of his cases involving investment treaty arbitrations and setting aside of international arbitration awards or landmark cases, setting precedent for various areas of the law. So thank you, Andre, for joining us today. Next, we have Jun Bautista. Jun is a member of King & Spalding's International Arbitration Practice Group and based in Singapore. He has represented clients across a number of industries under various arbitration rules and ad hoc proceedings. He has been listed as an arbitration future leader by Who's Who Legal and recognized in Chambers and Legal 500. Prior to joining King & Spalding, Jun was based in Hong Kong and worked in the international arbitration groups of Herbert Smith Freehills and Baker Botts. He was also the founding director of the ICDR in Singapore, was an associate at CSIP Salazar, and the law clerk for Justice Conchita Carpio Morales. In addition to representing clients, Jun is currently teaching the International Arbitration course for the LLM program of UP College of Law and an ADR course at the Angeles University Foundation School of Law. Thanks, Jun, for joining. Next, we have Mr. Shaun Yee. Shaun Yee heads the litigation and dispute resolution group of Wong Partnership. He also has the banking and financial disputes practice and partner in the international arbitration, financial services, regulatory, and Malaysia practices. Shaun Yee was a fellow of the insolvency practitioners of the Association of Singapore and is on the panel of arbitrators of SIAC. He's a fellow of CIARB and past chairman of the board of its Singapore branch. Shaun Yee was a member of the Law Reform Committee of the Singapore Academy of Law. Shaun Yee graduated first class honors from the University of Bristol and is admitted to the English and Singapore bar. He was a justice's law clerk with the Singapore Supreme Court before entering into private practice. Thanks, Shaun Yee, for joining. Next, we have Louis Ogzimmer. Louis is a co-chair of the Dispute Resolution Department of Romulo and heads the firm's arbitration practice. He's a member of the SIAC panel and has handled countless commercial and investment treaty arbitrations, both ad hoc and institutional. He teaches international commercial arbitration and private international law at the Ateneo Law School. Next, we have Ms. Patricia Gadel. Anne is a senior partner of Accra Law. She specializes in commercial and construction arbitration, as well as commercial litigation. Though she acts as an advocate in arbitration, Ms. Gadel likewise serves as an arbitrator and part of the SIAC panel and among other different institutions. She is likewise an accredited adjudicator and has published widely and frequently. She obtained her Bachelor of Laws degree from UP, where she graduated cum laude. She then proceeded to rank first in the 1996 Philippine Bar Examination and obtained her Masters of Law degree from Harvard Law School. So thank you, Ms. Rina, for joining. Then last of our panelists, we have Ms. Jane Yu. Jane is a senior state solicitor at the Office of the Solicitor General in the Philippines. She is one of the pioneers of the practice of international arbitration at the OSG, where for 2 decades she was the principal handling solicitor of some of the most complex investment arbitrations filed against the Philippines before different arbitral institutions and ad hoc arbitrations. She has participated in the drafting of the 2012 IBA rules on investor-state mediation and part of the UNCITRAL working group on the reform of investor-state dispute settlement at the United Nations. Jane was the first runner-up of the Nestor Balasili Awards for Most Outstanding Solicitor at the OSG. She also received an award for Outstanding Legal Service from the Office of the Executive Secretary. She's a member of a PIR and currently working on her thesis for her master's degree from Queen Mary University of Law for International Dispute Resolution. So let's now go to our main session of the panel. And since it's on virtual hearings, perhaps we should first discuss the legal framework on allowing the virtual hearings both in the Philippines and Singapore. So maybe we can first call on Louis to discuss the legal framework in the Philippines as to virtual hearings and international arbitration.
Okay, thank you, Thea. Good afternoon, everyone. Again, thank you to the SIAC for organizing this event, which I am sure will be very helpful and enlightening to everyone. Insofar as the Philippines is concerned, perhaps let's start with the legal framework of the Philippines. The Philippines is a signatory to the New York Convention, and it also adopted a law, Republic Act 9285, pursuant to which the Philippines adopted the UNCITRAL model law as the governing law for international commercial arbitration. So I will just focus on those 2 aspects. And pursuant to RA 9285 or the ADR Act of 2004, the implementing rules and regulations were issued under the leadership of the Department of Justice. So why are these 3 laws, if I may call them as such, important? First, with respect to the New York Convention, Article 5 of the New York Convention provides for grounds or specifies grounds for refusal of recognition of an arbitral award. And those grounds are actually mirrored in the UNCITRAL model law as essentially the same grounds for the setting aside of an arbitral award. And in particular, I would like to refer the audience to Article 1B and Article 1D, Article 5.1b and Article 5.1d of the New York Convention. Essentially, it says that an arbitral award may be refused, and in the case of the model law, it may be set aside in the seat if, under Article 1b, the parties are unable to present their case. And under Article 1d, if the arbitration procedure was not in accordance with the agreement of the parties or the law of the country under which the arbitration took place. So that is important for purposes of determining the validity of your procedure, i.e. whether in person, virtual, or any other means of conducting the arbitration. Now, if you look at 9285, the implementing rules and regulations, specifically under Rule 5 and Rule 4.19, it speaks of the arbitration being conducted in accordance with the agreement of the parties and in such a manner as the arbitral tribunal deems appropriate. So as with any arbitration agreement and arbitration proceeding, arbitration is a creature of contract. So the parties are free to agree on how they conduct their arbitration. And that is also reflected in Section 2 of RA 9285, the state policy honoring party autonomy. And if you look at the implementing rules and regulations, and that Rule 4.19, it actually says that failing any agreement of the parties, the arbitral tribunal may adopt the UNCITRAL arbitration rules of 1976. There is a specification on the 1976 UNCITRAL arbitration rules. Now, referencing now to the 1976 UNCITRAL arbitration rules, it also says that the arbitral tribunal may conduct the arbitration in such a manner as it considers appropriate, provided that the parties are treated equally and each party is able to present its case. So it mirrors the provision of Article 5 of the New York Convention, which I mentioned earlier. So those are the limitations for the arbitral tribunal, but it makes reference to a specific set of rules. And if you look at the further amendments to the UNCITRAL arbitration rules, particularly the 2013 version, you will note that I believe it's Article 28 of the 2013 UNCITRAL arbitration rules, that the parties, again, it reiterates the ability of the arbitral tribunal to conduct the arbitration in accordance with what it deems may be appropriate, including means of telecommunications that do not require the presence of the parties. In fact, the 2013 UNCITRAL arbitration rules even expressly cites as an example video conferencing. So going now to SIAC, the SIAC also provides in its rules that or grants a tribunal pursuant to its rules the ability to conduct the arbitration in a manner they may deem appropriate. In other words, it grants a tribunal such leeway. So first, look at the agreement of the parties. That's very important. What arbitration rules were agreed upon by the parties, because those arbitration rules are deemed integrated in the parties' agreement and therefore will form part of the arbitration agreement or the arbitration clause. Now, if there were no arbitration rules that were agreed upon by the parties and it falls into the hands of the arbitral tribunal how to conduct it, then pursuant to the laws and rules I mentioned earlier, the arbitral tribunal is arguably within its jurisdiction to choose virtual arbitration in the event that there are circumstances that prevent the parties or the arbitration tribunal from holding the hearings in person. So the beauty with SIAC, of course, is that the rules since I think it was since 2007 and up to the present rules, they have also expressly provided that kind of jurisdiction to the tribunal, which is to conduct the arbitration in a manner it deems appropriate. So that more or less explains the framework of the Philippines insofar as its laws, rules, and the New York Convention apply.
Thank you, Louis. So we have a lot of participants coming from Philippines and Singapore, and we also note that a lot of international arbitration cases have the seat in Singapore, but the governing law is in the Philippines. So maybe we can call on Mr. Andre to discuss the legal framework in Singapore this time regarding virtual hearings, especially since there's travel ban and Philippine parties may not be able to travel freely to Singapore for hearings. So thank you.
Right. Well, like Philippines, Singapore is also a party to the New York Convention. And basically, we have enacted the domestic legislation under the International Arbitration Act, which provides for it. And basically, it tracks largely the provisions in the model law for the setting aside of awards, which, as Ollie had mentioned earlier, covers situations where you are acting contrary to the agreement of the parties. In addition to that, obviously, the typical approach that parties may adopt in any efforts to set aside an arbitration award typically would be to go down also the breach of natural justice point. And with that, usually there's some kind of argument in relation to either a lack of reception on the part of the tribunal. I mean, you're supposed to hear and supposed to understand, but you have not done so, right? And sometimes they would also argue that no reasonable opportunity was provided to them to deal with certain aspects. So I think in that context, it serves also to draw the no-go zones or the danger zones in terms of any procedural orders that the tribunal may make in relation to virtual hearings. But coming back to the question, strictly in terms of a framework, there's no specified framework provided for virtual hearings in Singapore. There is no evidential act or anything that applies. And largely, the restrictions would be limited to two main areas. One is the arbitration rules and the agreement between the parties, which is usually encapsulated in the arbitration rules. And secondly, I think the mandatory applicable laws that may affect the arbitration. Taking first the rules, as Ollie has mentioned earlier, under the SIAC rules, I think that's Rule 19, right? The tribunal shall conduct the arbitration in such a manner as it deems appropriate, basically to ensure fair, economical, expeditious, and final resolution of the dispute. We always say EEFF, right? Economical, expeditious, fair, final. And some would say, this is the broadest possible mandate given to a tribunal to establish its own rules. And that is really very helpful to the tribunal. Apart from that, really, the other main issue is in relation to the mandatory applicable laws, right? The applicable laws typically would be obviously the law of the seat, the governing law of the contract, possibly the governing law of the arbitration agreement. So the virtual hearing regime, which is being ordered by a tribunal, must not infringe and cannot infringe, and certainly should not infringe on any of these mandatory laws, if there are any mandatory laws which restrict the ability to have this hearing done in a virtual style. So it could be embedded in a constitutional right. It could be embedded in a Evidence Act if it applies. But certainly in Singapore, there's no such.
I think we have some difficulty hearing Mr. Andre, but perhaps it's also part of the realities of virtual hearing per se. And bringing up with even if it's already with the best internet, some of the best internet in the world, we still experience this. But perhaps I can segue now with what Louis and Mr. Andre briefly mentioned regarding the legal framework. Since Jun also has background both as counsel and as a ICTR rep before, what are your views on the arbitration agreement? If it should on virtual hearing, should it be like in the SIAC rules where it's more broad in a sense as mentioned by Louis, or if it should be specifically mentioned in the arbitration agreement of the parties?
Thank you for that question, Thea. So I guess just taking a step back, so if you follow Louis' discussion, so as Louis mentioned, the tribunal actually has a broad discretion on how to conduct. I think we're having all sorts of technical difficulties. Sorry about that. So in theory, if we follow the tribunal has broad discretion to conduct arbitration procedure as it deems fit, that would theoretically include the power to conduct arbitration proceedings virtually or arbitration hearings virtually. And I think that's probably the sound way to interpret the rules. That said, I mean, you have to consider that parties are in a dispute and some parties may not be necessarily cooperative. Some parties may want to derail the arbitration proceedings and they may want to actually question the power of an arbitral tribunal to have a virtual hearing, for instance. So I suspect, from just to be on the safe side, while I think tribunals do have the inherent power to conduct the arbitration hearings virtually, it's probably best to explicitly provide that in the arbitration rules. And actually, that's what the ICC recently did when it adopted the 2021 ICC rules, one of the amendments to the 2021 rules is that it now explicitly allows the tribunal to conduct hearings virtually or remotely after consulting with the parties. So again, that's just to remove any doubt as to whether or not the tribunal actually has that power. Now, the next question, or at least the second part of that question that you asked, was whether or not the parties should deal with that in the arbitration agreement. In theory, why not? But I think the reality is that the arbitration agreement is usually not exactly front and center of what the parties are negotiating. The arbitration agreement is usually a midnight agreement. It's one of the last things that the parties really consider. And I think the reality is the shorter and the simpler your arbitration clause is, the better. So I think as long as the rules provides explicitly that the tribunal has the power to conduct arbitration hearings virtually, then I think that should already be a sufficient solution and keeps the arbitration clause neat and simple.
Here, if I can just add on to Jun's comments, which I agree wholeheartedly. The one thing I wanted to say is that increasingly, and I think you will find in almost every international arbitration proceeding, tribunals that are constituted will propose in this first procedure order a stipulation that they have the discretion to conduct hearings virtually. And they also will likely propose a stipulation that parties agree and that they will consent that no objections will be taken by them if the award or decision is rendered after a hearing is conducted virtually. So it's basically been like a boilerplate clause that's been developed over the last few months. And if you propose it right at the start of proceedings, I think all of us will agree that you're not likely to want to object to it. You're likely to agree to it, and that would resolve any issues as to whether the rules or your legal frameworks will provide for the conduct of a virtual hearing. So, you would expect that, to come out front, right, and center in the first draft of the procedure order.
Thank you, Jun. Thank you, Shaun Yee. So with apologies to everyone for our earlier technical difficulties, and this was initially one of my things I was worried about because it usually does happen even if you try to prepare. But so far, thank you again to we actually have a backup moderator, Mr. Bautista. So thank you for also helping us for this virtual hearing. And aside from that, if you also experience some difficulties with your hearings, we can also check the virtual, taking the arbitration remote guide of the SIAC, and we also discussed the technical hearing if protocol for if there's a failure for the virtual hearing. So since we're also now next to discuss the trends for virtual hearings and what maybe we can now call on Ms. Jane Yu to discuss the current trend she's been experiencing in the Philippines and also consider, for example, the difficulty in internet connectivity. So what has been your experience as government lawyers in doing virtual hearings?
Yeah, thank you, Thea. But first, before I answer that question, I would like to just contribute a point on the issue of whether the virtual hearings should be already incorporated in the arbitration rules, or should it be incorporated in the arbitration clause. May I just emphasize the rule of the seat of the arbitration with respect to the enforceability of an award that is rendered through involving virtual hearings. May I just point out that there are actually some cases, primarily in Switzerland, for example. There was an award, there was a decision of the Court of Switzerland, which declared that virtual hearings are not allowed because of the legal requirement that hearings should be made public. So the role of the seat is very important also, not only, and it's not only the institutional rules or the arbitration clause that are important, but it's also the law of the seat. So you have to be very careful about choosing the seat of your arbitration. Now, moving forward to your question with respect to the experiences of government counsels with respect to virtual hearings. It might surprise some practitioners that government lawyers are actually very adept at virtual hearings, especially those who have engaged in arbitrations. The current trend in local litigation practice of e-hearings was actually introduced to arbitration lawyers in government more than a decade ago. So, and because of that, we already know the implications of when the Supreme Court issued circulars pertaining to virtual hearings. And also because of that experience, we also know that we would be facing many challenges pertaining to virtual hearings. Now, these challenges, I would say, would include technological challenges as what we experience now. For example, the lack of internet connectivity almost always will be a hindrance to effective and efficient virtual hearings. Secondly, the lack of facilities and infrastructure to conduct virtual hearings is a real challenge for government lawyers. And I suspect that many of us in the Philippines have experienced this in our courts. The OSG, for example, where I come from, has had to upgrade its facilities, its technical facilities, and upskill its people in order to be able to handle the international arbitrations that are where the Republic is a respondent. Thirdly, there's also the difficulty of, for lack of a better term, humanizing the proceedings. Virtual hearings in arbitrations normally involve the presentation of witnesses as we are conducting it now. We are unlike in-person hearings, which I consider to be a contact sport. Virtual hearings do not really capture the demeanor of witnesses, the expressions of counsel, the observations of the tribunal, while they are substitute for in-person hearings. The intensity, the effectiveness, the impact of in-person hearings is not necessarily the same as that of virtual hearings. That said, the government lawyers, of which I am a part, welcome virtual hearings also as a cost-saving measure. We are spending public funds, and we are very conscious of that. And therefore, virtual hearings, particularly on procedural issues, is a welcome development for us. And those are the main highlights of my experience as a government lawyer. Before I end my answer, I would like to qualify that my answers are my own, and they do not necessarily represent the views of my office or of my colleagues, and particularly the mistakes that I made, they're my own.
Thank you, Jane. So we have briefly discussed the legal framework and the trends that we experience in virtual hearings. And since one of the biggest important factors of arbitration is also confidentiality, we hear a lot of the term Zoom bombing, and we also try to use a lot of different platforms. So maybe we should discuss also the security-related concerns for these video hearings. So maybe we can go to Mr. Shaun Yee to describe on who has the responsibility for ensuring the security of the hearing. Is it the tribunal parties or the arbitral institution?
I'll be happy to. Once again, thank you for being able to participate in this webinar today. And a pleasure to see so many friends virtually. I think when you speak about confidentiality and security, you're really talking about two specific aspects. One, maintaining the confidentiality of the hearing, the submissions that are taken in the proceedings, and you're talking about, secondly, I think security and maintaining the data privacy, security of documents, evidence that's presented, and also data privacy issues. The short answer to the question, I think, is that it is a joint responsibility to be assumed by all participants in the proceedings, certainly the tribunal and the parties, and to a certain limited extent, the institution. Unless parties want to save costs and make their own virtual hearing arrangements, I think typically what you will find today in most international arbitration proceedings is that parties will engage the services of a third-party service provider. That gives rise to certain cybersecurity risks because you would have platforms storing and hosting of documents being done by a third-party service provider. And these are issues which needs to be addressed. But I think, just reading through material over the last 12 months, security was obviously, a concern that many commentators had made and expressed their views on. But, with time, with the fact that, we're now a year and a half into the pandemic, and with the experience which the third-party service providers, the established ones, I think, many of these security and confidentiality concerns are probably mitigated. A number of safeguards have been put in, and I certainly can say that the third-party service providers that we've worked with, have essentially put in place various security and confidentiality safeguards, which I think addresses these concerns. I won't go into the specific aspects of that. I think one of my fellow panelists will tackle the question of how do you maintain confidentiality. But I just wanted to essentially provide an overview of the fact that this is obviously a real and live concern. Some institutions have introduced their own cybersecurity protocols. Experienced tribunals, I would dare say, have in fact themselves taken the lead in ensuring and making clear to parties that this is something that they need to ensure and enhance. Essentially, if you're using a third-party platform, some sort of document sharing proxy, you have to have the appropriate safeguards to ensure that all your documents and submissions are secure, and free from hacking, for instance. But I suppose the one thing that clearly has evolved and again become a must in international arbitration proceedings really is the drafting of a proper virtual hearing protocol. And that virtual hearing protocol will, amongst other things, ensure that security and confidentiality issues will be taken care of. At the start here, I mentioned and made reference to the SIAC guidelines. It's a guide on taking your arbitration remote. I think it's an extremely important document, for the international arbitration community to take note of. It's a very comprehensive checklist. It's a roadmap for discussion between tribunal and parties. Amongst other things, it has an excellent checklist on things to consider from start to the end of the proceedings, things that you need to do in choosing your right hearing platform, security issues, and even a remote hearing etiquette. Another protocol or at least a guideline that I would commend is the Chartered Institute of Arbitrators guidance note on remote dispute resolution proceedings, very comprehensive checklist. There is also a specific cybersecurity protocol, interestingly released in late 2019, before the pandemic really hit us, there was a working group involving ICA, the New York City Bar, and an organization called the International Institute for Conflict Prevention and Resolution. They work together on a protocol on cybersecurity and international arbitration. Altogether, I think 14 principles, which provides somewhat high-level guidance points, but very important points on how to enhance and ensure that you have information security measures. And finally, I should mention also, the SOL protocol on video conferencing international arbitration that I think many of you will be familiar with. It was introduced actually in 2018 by a group led by Kevin Kim, a very prominent international arbitrator and counsel. They were ahead of their time because they had the foresight of identifying several core aspects which needed to be dealt with on due process, confidentiality, and also technology. And in fact, I think Annex 1 of the SOAP protocol has a very comprehensive list of security requirements, which they commend to parties and tribunal as to what they should implement when they conduct a proceeding virtually. So you actually have a lot of material out there, which makes it very clear that confidentiality and security cannot and must not be compromised. And a lot of information to guide parties and tribunals on these matters. I should just mention that there are obviously also data protection considerations, but these do sort of like vary from jurisdictions and the application of various national legislations. And frankly, that by itself can be the subject matter of another webinar. Thank you.
Thank you, Shaun Yee. So maybe we can call on Ms. Trina to discuss further if she has any more suggestions for how to have a more confidentiality for arbitrations and virtual hearings, especially for cross-border cases.
Thank you, Thea. And as everyone has mentioned, I thank you for allowing me to participate in this webinar. So Shaun has been was mentioning two aspects of confidentiality, but I think I'd like to expand that to four. And so that will be the context of my discussion. You have confidentiality of the proceeding itself, making sure that only those who are supposed to participate and be able to observe are actually participating and observing. The second aspect is the recording of those proceedings. Those things must be kept confidential as well. Then you have confidentiality of the submissions. I think Shaun, you mentioned those, the papers, the evidence that have been transmitted across parties to the tribunal or to the institution. And the fourth aspect, which I think goes into the data privacy that Shaun was mentioning, was partly data retention. And I think that's a part that we sometimes forget, that it's also part of the confidentiality obligations. So looking at all those aspects of confidentiality, I think, as mentioned by Shaun, we can address these things, making use of technology, making use of the parties' agreement and prior consent through cyber protocols that have been adopted by the tribunal in every case. And there are practical tips, I think, that a tribunal may want to look into to making sure that after technology has been obtained, consent clearly given to keeping things confidential, that it will actually be observed. So, I mean, confidentiality breaches happen because, as Thea, you mentioned, Zoom bombing. That's a misuse of technology, the ability to hack. If nobody is wanting to be naughty and you misuse technology, we'll not be discussing this as an issue. So technology will also help us address the misuse of technology that leads to breaches. So we have to have consciousness that you have to have the appropriate providers, you choose the correct platform, and that you make sure you have the necessary features to ensure security. Oftentimes you have a lot of features available, but out of convenience, you don't use them. Like oftentimes you have hearings with embedded passwords, when in fact, that is best done separately. You don't embed the password in the link so that there's an added layer that whoever gets the password can use the link. But if you only receive the link and not the password, you cannot enter the meeting. After the Zoom bombing incident, obviously, they put in place other things such as the waiting room, ability to remove or ban attendees, and that helps in providing additional layers of confidentiality. But the second aspect of storage of the recordings, we have to make sure that these recordings are stored where I don't think we can say we can totally eliminate hacking, but at least bring it down to a degree that really makes it difficult for the ordinary hacker who doesn't really just want to get into your records to be able to hack it. So you should get storage facilities, unfortunately, that are not free. Most free storage facilities will not have the same features for security purposes as a paid database or server or storage facility would be. So it would be good if you can engage someone whose reputation for providing that kind of support is such that you can rely on them. So talking to other tribunals and other parties and users of these support providers may be good. So you can get feedback and you get the appropriate individual to provide you the support. So the second one is, as I mentioned, party consent and agreement. Shaun, you mentioned this already on having a protocol that everyone addresses and discusses, and the collaboration helps because everyone discusses the possibility considering their personal circumstances. Like, for example, if Jane, she's being in government, will have a different mindset than a counsel who comes from, I was going to say Singapore, but what would happen with Andre earlier, they may now have a different mindset as well. But so typically, if you have a first world mentality, I have less issue about internet connectivity. But if one party is from an emerging market like the Philippines, I will have more issues and I will drill down on those issues with respect to me. So having the collaborative effort of making sure the protocol addresses everyone's needs on security, that will, I think, make things work. But in addition to that, the tribunal needs to drill down on certain behavior from the parties, such as making sure the parties disclose who are in the room in a particular witness's video feed, or that they can attest that no one is there other than the witness who is participating, and that if there happens to be someone who suddenly enters, that they will do so. They will disclose to the tribunal and to everyone, just so that they make sure that everyone is aware who can hear and who can view, right? In addition, recording, obviously, when one records, we get notified. But there are ways of recording that we will not see. So the parties have to be informed that they cannot do this without the consent of everyone else and of the tribunal. Once you have that kind of protocol, once you have agreed on the details such as those, you will be able to proceed with your arbitration confident that the parties are aware of what is expected of them and that they will hopefully abide. Okay, on data retention, I think you can put that in your protocol as well as to how long you need to keep these records available and when you can purge. But the last thing I wanted to mention was that, yes, you have your agreements in place in the cyber protocol that everyone accepts. You have your technology that protects all these from potential misuse of hackers who may want to invade your meeting or actually hack into your database. Parties' behavior must also be controlled because all it takes is one person missending the link to someone else or sharing a document that they're not supposed to share or allowing people to come into a meeting. So the practical tips in a tribunal hearing is you may want to ask each participant to pan their camera to make sure no one is in the room. You may want to prevent the witnesses from having virtual backgrounds, which prevent the tribunal and the parties from actually seeing who's behind the background. You may want to require a particular witness to wear a headset or headphones so that even if somebody accidentally walks in, no one will accidentally hear what is being said, except what is being said by that witness himself or herself, right? And then you may want to ensure that the links are separated from the password, sent a few days prior to the hearing, so there are less chances of it getting forwarded. All these things can help you make sure you have confidentiality in place and that the parties are comfortable that the confidentiality will be kept as a priority in the proceedings. In the Philippines, there's a peculiarity. I'm not in other jurisdictions, I'm not aware, but in the Philippines, confidentiality is legally mandated, so that if you happen to breach it, there are legal consequences to the person who breaches it. So that is an added assurance, at least in the Philippines, that there will be no breach of confidentiality obligations. So I hope that helped in how to make sure confidentiality is maintained.
Thank you, Ms. Rina, for that comprehensive summary for the tips that we should have for maintaining confidentiality in arbitrations. So now maybe we can move to Ms. Jane on how state entities should also have extra precautions when it comes to their international arbitration cases.
Yes, thank you, Thea. Again, thank you to Trina for pointing out the difference in perspectives. Preliminarily, I would like to point out that confidentiality is not automatically a requirement in all arbitration proceedings against states, such that in answering your question, I would have to distinguish treaty-based arbitrations from commercial arbitrations. In treaty-based arbitrations, there is in fact a movement towards increasing transparency in arbitrations. In treaty-based arbitrations under the UNCITRAL rules, for example, parties have the option to include the 2014 rules on transparency in treaty-based investor-state arbitration, which allows for public hearings unless one of the parties invoke exceptions under Article 7. Likewise, under the exceed rules 32.2, amicus curiae briefs and public hearings are allowed unless the parties object to such a public hearing. Now, in commercial arbitrations, however, the rules on confidentiality equally apply to state arbitrations. For example, Article 23 of the Philippine ADR Act expressly provides for the confidentiality of arbitration proceedings. The arbitration proceedings, including the records, evidence, the arbitral award, is considered to be confidential and it's not allowed to be published except with the consent of the parties or for the limited purpose of enforcement. Now, then as a general rule, the IBA rules on taking of evidence provides that evidence that is produced is supposed to be used only in connection with the arbitration. And the only exception is that if you are allowed to disclose it to fulfill a legal duty, pursue a legal right, or in reference, again, to enforcement. Now, for the state, with respect to the confidentiality of its privileged information, the many of information that passes through the hands of government are considered privileged in the sense that they may be classified as executive privilege. Some may be considered as state secrets. Some information which could impact on public order and national security are considered privileged. And because of these, from my experience, states normally require separately from the institutional rules the execution of non-disclosure agreement or a confidentiality agreement, which outlines the use of the information that is obtained through the arbitration. The information that is generated through the arbitration is usually regarded as exclusively to be used for arbitrations only. Likewise, because of the highly technical nature of the processing of data and the production of documents, you would have to also engage, again, for lack of a better term, legal technologists while lawyers focus on the arguments, the law, the facts, you would have to engage, for example, a service provider that would assist you in production of documents, in redacting certain documents, etc. Um, Personally, as a matter of protocol, I would require the execution of a non-disclosure agreement between my client and that legal technologist, because the legal technologist has to be bound under contract also by the confidentiality agreement between the parties. And that is one of the assurances that confidential information does not leak. Secondly, I also agree with the execution of cybersecurity protocols between parties. At the onset, at the start of the arbitration, the parties have to have a cybersecurity agreement as to how the information will be used, stored, reproduced, and presented to each other and to the tribunal, so that there's actually a limit on the number of persons, for example, who can gain access to the information that is being generated. Thank you.
Thank you, Jane, for sharing your views as a government lawyer, especially since in a lot of arbitration cases handled by the state, these are usually high value and they really can dictate public policy issues. So thank you for sharing your views on a personal level. So now maybe we can go on the discuss due process concerns with regard to virtual hearings. So maybe we can call on June to discuss how the due process and fair and reasonable opportunity to present the case requirement be met in virtual hearings, especially involving Filipino parties.
Thank you for that, Thea. So as Louis mentioned earlier again, he mentioned that the Philippines is a signatory to the New York Convention, that the Philippines has adopted the UNCITRAL model law, and that both of these instruments actually cite or require that parties be able to present their case. Otherwise, then it would be either a ground for non-enforcement or refusal to enforce, or a ground for set aside. And that's, I think, it's fairly obvious why you require a party to be able to present one's case. That's essentially due process. Now, in the Philippines, I'm not aware of a particular Supreme Court case where the Supreme Court has distinguished between due process in arbitrations versus due process in judicial proceedings and administrative proceedings. As far as I'm aware, there are only two types of procedural due process. There's the judicial process, and there's also the administrative due process. I don't really think that there's a fine distinction between the two. I mean, if you read the case law, essentially it's really the opportunity to be able to present one's case. And whether or not there's a violation, that I think ultimately is a question, it's a case-by-case basis. I think in the context of virtual hearings, I think I think it was already alluded to during this webinar, I think the main issue with respect to Philippine-based arbitrations or Philippine parties is that there could be an issue with respect to it not being able to present one's case fully if, for instance, you have internet connectivity problems. Although that's not just a problem in the Philippines, that's a problem, as we've already seen, it can happen anywhere. It can happen in more developed jurisdictions. So by itself, I mean, having a virtual hearing should not per se, infringe of one's ability to present one's case. Having said that, we do have to be conscious that there could be some instances where a party may be unable to present one's case. But I think you just can't object to having a hearing virtually. You basically need to present some sort of justifiable reasons why you shouldn't have the hearings virtually. So for instance, we've had this pandemic for about a year now, and most of the arbitrations that I've been involved in, we were adopting a wait and see attitude. But as it became apparent that this situation wasn't going to change anytime soon, the parties just basically, either the parties or even the tribunal basically said, look, let's just have the hearing, let's have it virtually. Otherwise, we're going to have this case drag on for years until we wait for vaccines. So that's essentially what's happened. And I think for the most part, there were no due process concerns. We've always had, there's always some technical glitches, whether it be from the parties or from the arbitrators. But by and large, that was, it was fairly smooth. And these involved, parties from less developed countries as well. So I think it's not. Obviously that you may have issues with technology, but it's not something that is insurmountable. With preparation, hopefully, as we've done in other webinars and other hearings, with the preparation, hopefully you can minimize the disruptions. And even if you don't, you can find ways of mitigating these disruptions. So for instance, if the tribunal can, for instance, set more allowances. So instead of maybe having, let's say, a 6-hour or 8-hour hearing schedule a day, you can have maybe 6 hours. So just in case there are technological problems, you have some allowances. So things like that. So I think, and tribunals, I think, are quite mindful and sensitive to these considerations.
Thank you, Jun. So maybe now we can go to Andre to discuss possible measures that can be done by the tribunal on if another party refuses to proceed with the virtual hearing.
Well, I think firstly, a lot depends on, I think, obviously the tribunal's assessment of the parties involved, right? I think firstly, the tribunal has to make sure that opportunity has been given to the parties to ventilate whatever it is that they wanted to ventilate. And, obviously, if, for example, the parties have previously said, oh, I think it's going to be very, very difficult for me to get this particular witness or something to do a virtual hearing because he lives in the mountains somewhere or whatever it is. And, if that had been flagged early enough and directions have already been given, and adequate time has been allowed for the witness to get to a location where there's adequate connectivity, then I think in that sort of situation, you could reasonably expect to go on with the hearing, whether or not the witness is available, right? Or if on the other hand you believe that it's due to something which has arisen at the last minute, right? Then you could obviously defer the hearing. But again, obviously, there are issues of timing involved, and if you're going to defer the hearing, then you probably want to make sure that, as far as possible, that it's going to be, not a long drag between the current hearing which is being put off and the next hearing. So, it can happen in many different ways, right? And in a situation where what party doesn't attend the hearing, ultimately, assuming that enough time has been given to the parties to address all these issues, the tribunal will typically go on with the hearing. I mean, we had a case where it was an emergency arbitration hearing, and the other party didn't want to participate. So we were hooking up directly, remotely with the emergency arbitrator. And technical failure doesn't only happen to panelists, it happens to emergency arbitrators too. And, you know, we did a test run the day before, it worked well, but on the actual day, it just failed. The system just didn't work. So fortunately, the emergency arbitrator was in Singapore, and, you know, she basically decided to do a physical hearing. And, you know, obviously we did a physical hearing in our office with us and the arbitrator. The opposing counsel had indicated he wouldn't turn up for the hearing, but we didn't want any issues we didn't want any allegations of wrongful conduct either on our part or the arbitrator's part. So we had it recorded, and we extended a copy of the recording to the opposing side. So I think, you know, a lot depends on what issue arises, when it arises, how it arises, and the tribunal's assessment as to the legitimacy of those reasons, right? But generally, assuming you believe that the reason is legitimate, then obviously you try to accommodate it as far as you can. And if you don't believe that it's legitimate, then, you know, you push on with the hearing.
Thank you, Andre. So maybe briefly, we can also discuss some tips from both perspective of the arbitrator and counsel. But first, for an arbitrator, maybe we can call Shaun Yee to discuss some safeguarder tips for the better conduct of virtual hearings.
Happy to. Having conducted several hearings in the last year, actually both as counsel as well as sitting in the tribunal, I probably want to share some thoughts on, you know, what would be effective advocacy in a virtual hearing setting. You know, much has been written and commented about how the human brain may process information differently in the physical as compared to a virtual setting. I think you have phrases like Zoom fatigue, you know, the difficulty in maintaining concentration, you know, looking at the screen for extended periods of time. And often, you know, the problem is aggravated by time zone issues. Some have suggested, and, you know, we heard from Jane earlier that, you know, as compared to a physical hearing, you don't quite see the body language, you can't quite see the demeanor of the witnesses fully during oral submissions, or, you know, when witnesses are giving evidence, you know, that perhaps might have an impact on the forcefulness of the advocacy. I think that's probably correct, but at the same time, I probably take the view that virtual hearings have worked quite well. If counsel, I think, pays full attention to what his or her job is, and at the end of the day, that is to persuade the tribunal of the points that their client, their party wishes to pursue. It's one thing to be able to emphasize your voice intonation, the gesture, you know, dramatic way, body language, obviously very effective tools, you know, in a physical setting. But I think, you know, in a virtual setting, there's a lot to be said about essentially making clear that your points are communicated clearly, you know, and succinctly to your audience, and that is the tribunal. And I think the main point here really is making sure that you continue to have that connection, although it's not in a physical setting, but in a virtual setting. And what do you mean by that? Now, I had actually thought that in a virtual setting, you could see your tribunal because you have all of them on your screens at the same time. And, you know, those of us, you know, who have conducted hearings in sort of the U-shaped setting will know that when you're cross-examining a witness, you're really looking at a witness, and you can't quite sort of like keep track of, you know, what your tribunal's facial expressions are. Whereas right now in the virtual setting, you could see all, you know, the faces at the same time. You will know if your arbitrator is dozing off. You will know if your arbitrator is paying attention. You will know if your arbitrator is lost, frantically looking for a document, or you will know if your arbitrator has had technological disruptions, you know, the screen freezes. So, I think the point to emphasize really is just pay attention, continue to keep that connection. I've seen instances where, counsel is just so frantically absorbed in wanting to get the answers out from the witness during cross-examination and failing to pay attention to the fact that the arbitrator was probably 5 pages behind because he or she is looking for a particular document to check on. It's just really keeping pace, of what's happening. I actually take the view, I mean, in all honesty, a lot of people say, look, as arbitrator, you have to sort of like, keep track of the pace of what's been happening. But in reality, I think maybe the simple honest tip that I will give to counsel is, it's not really for the arbitrator to keep track of things, but rather for counsel to make sure that they are keeping track of the arbitrator. Don't lose them in a virtual setting, because that beautiful point that you may have made in your oral submissions, that may well have just been lost because your arbitrator wasn't paying attention and was distracted by something else. But you will know in a virtual setting whether your arbitrator is paying attention. So don't lose that connection.
Thank you, Shaun Yee, for your advice, especially it's needed now with a lot of virtual hearings that we have. So maybe lastly, if we can call on for tips, we can call on Louis if he has any additional tips for conducting virtual hearings based on his experience, like what has worked and what did not work. You're muted, Louis. Sorry.
Rookie error, sorry. I actually did a long list, but in the interest of time, I'll just focus on what I feel would be the most important things, which are based on experiences from conducting virtual hearings, both in arbitration and sometimes in litigation, but more in arbitration. First of all, of course, the parties have to first make sure that virtual hearings are allowed, either by virtue of the agreement of the parties, the agreement with respect to the rules that they have adopted, like SIAC, for example, and also with respect to the laws that apply in the seat or where the arbitration is theoretically taking place. Because as I mentioned earlier, failure to account for those things will be a ground to set aside or refuse an award. The last thing you want is you worked hard preparing for an arbitration hearing, but you forgot that there are grounds to set it aside or refuse recognition. And for that, you have to look at the New York Convention. Assuming everything is done, that there is no issue with respect to validity of virtual hearings, then that's where you now go into what are the practical things that you have to look at. First, you have to brief your witnesses and your team. It's when the lockdown suddenly started, I was in the middle of teaching. I had already conducted like 3 actual in-person classes, and then the lockdowns happened, and then I had to switch to Zoom. And for a moment, I was actually doing my drawings on paper and then showing it to my class like that, which is a bit embarrassing. And then you realize the tools are actually there. So know the platform that has been agreed upon by the parties or has been recommended by the institution or by the tribunal, and familiarize your witness with that, so that if the witness will be using slides or any resource material, he or she would know how to share the screen, for example. And make sure that the witness is also briefed as to what will happen if he or she gets cut off. The last thing you want is your witness panicking. I mean, it's stressful enough for a witness to be going through cross-examination and being asked questions by the tribunal. What is even more stressful is if he or she is worried about the technical difficulties. So brief him or her that if this happens, this is what we're going to do. Don't worry. Ideally, you should be in the same room as your witness, so that if you get cut off as counsel, you don't want your witness continuing his or her testimony without you actually getting to observe what his answers was, what her answers was. Second, you do an internal dry run. You have to do that. You have to organize an internal dry run among your team members and among the witnesses, both factual and expert. Ideally, you do it at the same time as the actual hearings, because that will also determine the amount of traffic and the strength of your signal during the actual hearing times. Second, you have to also know the rules that are in force in the jurisdiction where your witnesses are. So your witnesses may be distributed in different jurisdictions. One may be in the United States, one is in Singapore, one is in Metro Manila. And you have to know what are the restrictions and the rules in all those jurisdictions. For example, if your witness is in Metro Manila and you're going to present a witness, in the Philippines, if you were to conduct a virtual hearing now, when a witness enters a building, he or she is required to wear a face mask and a face shield. So you will now know that you will be cross-examining a witness who's wearing a face mask and a face shield. And you have to be able to explain that if you feel that that is something that will make the balance between the witness of one party and the other is no longer equal. So you have to know what the rules are. Third, you also have to have a sufficient setup. In arbitration, wherein you're an in-person hearing, you have a setup for the transcripts, you have a setup for where essentially you only need a setup for the transcripts because the tribunal and all the witnesses are there. In a virtual hearing, you have a setup for each of the tribunal members. You have to have a screen for each of them, assuming they are all in different locations. You have to have a setup for the witness. You have to have a setup for the transcripts so that if it's being transcribed in real time, you can make a correction if there is a crucial typo or incorrect typing of what your witness or the witness of the other side has said. So those are things that you have to also seriously consider. And of course, you have to do, fourth is, you have to do a dry run with all the parties. At least once. You cannot afford entering a hearing with the tribunal, with the other side, with the witnesses, without having conducted a dry run with the other party. You have to agree with the other party. Let's set a dry run 1 or 2 weeks before the hearing. Again, ideally at the time when the arbitration hearings will actually be conducted. And I guess finally, know the limits of your witnesses, the limits of the others, and your own limitations. What is the bandwidth of your of your witness, so that you know, and what will happen if they lose that bandwidth? Because some applications actually eat up more bandwidth than others. I had to study this because we were encountering difficulties with different bandwidths. And last but not the least is, if you have to have a breakout room, even if the arbitral institution will provide it for you, as a matter of security, you may want to consider using a different platform. I've seen nightmares where in a breakout room, suddenly, for some technical glitch, you find yourself in the same breakout room as where the arbitral tribunal is. I mean, if you were at the point criticizing what someone said, and you fail to realize that you're in the breakout room of the arbitral tribunal, then that can create a problem. So as an additional measure, you may want to consider having a different platform internally as your breakout room. So I'll limit it to that so that we can have time for questions.
Thanks, Louis. So maybe before we can get some questions from the registrants, maybe we can first go to Ms. Trina to discuss possible issues on enforcement.
Okay, thank you, Thea. I'll make this brief. Some of the items here that I intended to mention were actually covered by some of the other panelists. So in the Philippines, the issue as to whether there will be a possibility of lack of enforcement by mere reason of there being a virtual hearing, you have to address, as Louis mentioned, whether the Philippines is the seat and only the seat. So if it is the seat, there is no prohibition in the Philippines of having virtual hearings. There is no mandate in our ADR law that requires hearings in arbitration to be physical. So there being no prohibition against virtual hearings and no express requirement for face-to-face or physical hearings, I very much doubt that that in itself would be made an issue and be sustained as a ground to object to the enforcement or recognition of a particular award that is seated in the Philippines. So the more crucial question is whether the other ground, as mentioned by Louis, also that is part of the New York Convention, that is also mirrored in our laws, is the fact that the due process possible objection on that a party was, because of the virtual hearing, unable to present his or her case. I think the question first is, will the mere decision of having a virtual hearing render this ground available? And I agree with June, it won't be. It's like any other hearing. You still have to prove that you were unable to present your case because of that decision. And despite all the possible technical difficulties and imbalance between parties because of their respective infrastructure, in itself, I don't think the decision to proceed with an arbitration on the basis of a virtual hearing will be a ground to refuse or to refuse recognition or enforcement. It is, however, the manner in which the hearing is conducted. And I think that's where I think the tribunal has to be able to balance. Yes, the parties have agreed to a virtual hearing, but at a certain point, the tribunal should be able to weigh the due process against the process that they agreed to. So if it, in the course of the hearing, it comes to their attention that it's no longer fair because the balance is not there, because one party's connectivity is so bad at a certain time and date, the tribunal must be able to make that decision to either suspend the proceedings for a while until the connectivity stabilizes, or to say that we will not have it today, we will completely defer to another day. Or if it is repeated that one party's connectivity is so bad because everyone is coming on with video streams and the bandwidth is not good, or at that point in time, it's really not possible, the tribunal must decide, I will terminate the virtual hearings and have at site. So the tribunal must not be so stuck in their decision to have virtual hearings. There must be a willingness to have physical hearings when the circumstances require. So when will you have that? As Louis mentioned, it's good to have a dry run. And you have a dry run that you don't just appear and then talk and then say, okay, everyone good. If there are documents that have to be shown, evidence that have to be accessed, videos that have to be presented, then those things must be tried out as well. The witnesses must be where they are intending to testify from and use the device that they're going to testify through. It's not that you have it in one place for the dry run and then come the real hearing, you're using another thing and everyone gets surprised with the difficulties. But when everything is in place and when the tribunal is sensitive to the possible imbalances, there should be no issue by the fact that you have virtual hearings conducted as a means of presenting evidence. That should not be made an issue. So for so long as everyone is sensitive to that, there's a backup plan in the event that a disconnection happens. And there are contingencies that you can actually plan out for a separate channel just in case this particular Zoom platform suddenly becomes unavailable. There are backup channels that you can have, backup modes of communication so that the witness can tell the tribunal, I'm having a problem, or the lawyer can say, I'm having a problem. And so for so long as everyone is on board on that and agreed on that kind of process, there should be no issue. And as mentioned by Shaun Yee earlier, you can actually have an order early on where they agree that the decision to have a virtual hearing is the appropriate one for the case, is a desirable one, and that the parties agree that they will not raise that decision to object to enforcement later on. But as I said, that is one step that will remove one objection, but the actual conduct of the hearing is another. And the tribunal is the one who is tasked to make sure that is done fairly and equitably so that no party can complain.
Thank you, Ms. Rina, for your comprehensive remarks on the enforcement for virtual hearings. So we have room for just one question. And the question is, to the Philippine speakers, in an ad hoc setting, would you make the proposal for a virtual hearing in your TOR or your procedural order one? Do you propose it in detail or mentioning only a protocol? So does anybody want to answer this?
If I may take first jab at that, I think it's always safe to have the parties agree so that there will be no questions later. The problem really is if the parties don't agree. One of the things, a workaround there is if the parties were to agree, for example, in terms of reference, to adopt the IBA rules on taking evidence. Because the IBA rules on taking evidence define an evidentiary hearing as it includes essentially a virtual hearing. And another one is, as I mentioned, by Philippine law, assuming Philippine law is the governing law, there is a default to the UNCITRAL arbitration rules. So whether it is the 1976, but more comfortably the 2013 UNCITRAL arbitration rules, there is a specific provision there that allows the use of virtual hearings. And the UNCITRAL arbitration rules are actually in the implementing rules and regulations that absent even an ad hoc arbitration, unless the parties agree otherwise or the tribunal determines it is inappropriate, the UNCITRAL arbitration rules shall apply.
Thank you, Louis. Does anybody else want to add to Louis' comments?
If I may, Thea. I agree with Louis that it's good to have an agreement beforehand. That helps also in enforcement, right? As I just mentioned. It's good to have a lot of contingencies discussed because the collaboration of everyone in coming up with the various scenarios that they plan out for makes them invested in the process. And, they're less likely to make any form of objection that they were not fairly treated. But too much detail may be counterproductive because it may become inflexible. So there should just be a correct balance. And referring to something that has already been drawn out, like the IBA rules as mentioned by Louis, may be a good solution.
Thank you, Trina, for your comments. So that concludes our SAAC Philippines webinar for this Friday afternoon. And I thank everyone, especially our panelists who are very busy to take the time on their Friday to join us for this session. We had around 200 plus participants this afternoon, and I hope you learned something from our panelists. And I just want to remind everyone that you may also see the guide on the SAAC's guide on taking the arbitration remote. It's on the SAAC website, and it discusses from the selection of the platform to the protocol, as mentioned earlier, protocol for technical failure, how documents are to be presented, etiquette during hearings, and for breakout rooms. So we also want to thank the PIR and the IBP for supporting the event. So thank you very much, and I hope you have a good rest of your afternoon and evening, and have a good weekend. Thank you. Thank you to the panelists.
Thanks, everyone.
Thank you, everyone.
Thank you. Thanks, everyone.
Stay safe.